Government prosecutors file their response with the United States Supreme Court. We can see it here. It's a 34-page document. We are going to go through it in detail. These things usually have some nice summaries that we can really pull some teeth from, and we are going to dive into that. But before we can properly do so, we have to understand what we are talking about, because there's been a lot of activity in the Trump Mar-a-Lago saga. And here on the screen, you can see the beginning where this all started. And remember, we're talking about these Trump documents. When the FBI raided his residence, they came in, they found these documents. In my opinion, they pulled them all out of separate boxes and then threw them on the ground here for a photo op. But the point remains, they took the documents. And we are fighting about a very small sliver of the entire pie. If you recall, there was about 11,000 documents totaling maybe 200,000 pages, but a small subset of that 11,000, 100 of them were actually classified. We had two categories, the non-classified documents and the classified documents. So we're not talking about these 10,900 documents. Those have already been dealt with. We're only fighting about these classified materials. Now, Trump's team is saying that they don't have to give these 100 documents to the U.S. government. The DOJ, the FBI, they took the documents out in these boxes and they've held on to them. And Trump said, those documents are not yours. Those have to go to a special master, because there's all sorts of force fields that Trump as a defense can exert over those documents to protect them, namely attorney-client privilege, saying, hey, government, you think those are yours, but they're not yours. I got attorney-client privilege over them. Those are executively privileged. They're not yours. These are personal records. They're not presidential records. And there's precedent for this in the Bill Clinton sock drawer case. We've also talked about declassifying documents. So maybe those 100 documents that were classified are no longer classified and they're not in the appropriate category. So Trump's team is raising all sorts of issues with these. They're saying you don't just get free range access to our documents because you say that they're classified. You can't just presume that they're yours because you put a sticker on it. That's ridiculous. But that's the argument that the DOJ has been making. So all of these documents, they got filed with the FBI. Donald Trump filed an action with the district court. Of course, we know who received that. That was Judge Eileen Cannon. So we're working our way up the tree. Judge Eileen Cannon appointed Special Master Raymond Dearie to come in and help with some of these documents. Raymond Dearie said, perfect, I can't wait to dig into all of these documents, including the 100 classified materials. And so this was all going according to plan. Special Master Raymond Dearie is going to take those documents and then categorize them and say, oh, no, Trump, you actually don't have privilege over this. You don't have attorney-client work product privilege, or you do. Or these are presidential records, or these are personal records. He's going to be the referee to help over this whole thing, because Judge Cannon communicated that the DOJ was kind of screwing a lot of this up. Raymond Dearie starts to go through the boxes. The order hits. Then the U.S. government filed an appeal to the 11th Circuit. They took this up. They appealed two things. One was about whether they could continue to prosecute Trump. They can. The second was about whether they had to actually give these 100 classified documents over to the special master. The 11th Circuit said, oh, yeah, you definitely have to give those over to this. You actually don't have to give those over to the special master. Judge Cannon said Raymond Dearie was going to referee all these things. The 11th Circuit said, nope, no, you're not. Those are going back over to the FBI and the DOJ. No referee over the 100 documents. So then Donald Trump filed this document here, the appeal to the Supreme Court, and we read all of that in a prior video. We did a deep dive, read through that whole document as well. He appealed the 11th Circuit ruling, which did not give the documents to the special master, which stopped that from happening. He took it up to the Supreme Court, and he said that the special master order that came out from Judge Cannon was not appealable. In other words, because of the nature of the appeal, it's called an interlocutory appeal. It's an appeal not of a final judgment, but it's an appeal of an intermediary proceeding. In this case, it was the appeal of the appointment of the special master, not an appeal of a guilty conviction. Just as the case is progressing, we got to appeal just this little thing. And so Trump said, okay, well, they did that. The 11th Circuit ruled on it. It went against us. But the 11th Circuit, they didn't have jurisdiction over that issue in the first place. They don't have the ability to rule on an interlocutory appeal. So they filed that up to Judge Clarence Thomas. Judge Clarence Thomas, you see here, he's been the subject of a lot of scrutiny lately because of his wife, Ginny Thomas, and because he's a conservative and liberals hate that. And so he is the person in charge of this district. And this district now is, of course, being monitored by the Supreme Court because Judge Clarence Thomas, as we know, is on the United States Supreme Court. And so we're going to get the full court on this thing, I would imagine, sooner rather than later. But you can see this is what the docket looks like. From the United States Supreme Court, you see that it was originally docketed on October 4th. The appeal is from the 11th Circuit. And if you'll notice that Judge Clarence Thomas, because he presides over the 11th Circuit, he said that the application was filed and that the government response was due by Tuesday, October 11th at 5 p.m. Eastern. And you can see October 11th at about 4 p.m. Eastern, the government filed their response, the response to the application from the respondent United States. So they just got that skidding in there, as usual, right before the deadline. And now let's take a look at it now that we have the background and we understand exactly what we are looking at. Government prosecutors respond in the Supreme Court of the United States. Donald Trump filed an appeal contesting the withholding of the 100 classified documents from the special master. This is Donald Trump versus the United States up on appeal from the 11th Circuit. You see, the title of this is from the government prosecutor. Her name is Elizabeth. She says, "This is our response from the government in opposition to Trump's application to vacate the partial stay issued by the United States Court of Appeals for the 11th Circuit. That partial stay is stopping. It's staying the order that Judge Eileen Cannon already granted, which was going to give the special master 100 documents. So Trump says, I want the stay to go away. And the government is saying, no, we want the stay to stay. Do not vacate it, Supreme Court. Here's what they have for us. They are referencing the related proceedings, of course, out of the lower courts, along with the search warrant case. And this is the Solicitor General respectfully files this response in opposition to Trump's request. This application, writes government prosecutors, concerns an unprecedented order by the district court, that's Judge Eileen Cannon, restricting the executive branch's use of its own highly classified records in an ongoing criminal investigation. Now, this is the issue that we have talked about many times. They are sort of presupposing this. They're saying, as you can see, it says, these documents are already ours. It's our own documents. It's our own. See this there? They're not even contesting ownership, where this has been the entire basis of Trump's argument. He says, no. You don't just get to presume you own those things because you have your classified sticker on there. No, I mean, there's all sorts of things that we can do that supersede your possessory interest. We can actually say that those documents are ours because of executive privilege, attorney-client privilege, or any other basis for it, including the declassified or the personal records sort of exceptions or escape hatches here. But they're saying it's ours. And therefore, because it's ours, we say they're ours and we know they're ours. Therefore, it is unprecedented that you wouldn't let us do something with our own materials. But Trump is saying you haven't proven that yet. And so did Judge Eileen Cannon. That's why we have the special master, because he's going to help us decide this, who owns what. But they call that order appointing a referee unprecedented. And they sort of forget the fact that they raided, I guess, the president's house in Mar-a-Lago. You want to talk about unprecedented? My goodness. They're saying, but we, now as the DOJ, we have been stopped from running roughshod over the process. And for them, I'm sure that is unprecedented. Yeah, they're not used to that happening. They're used to doing whatever they want. They just pick up the J6ers and just throw them in solitary, and that's the end of it. Nobody even blinks an eye. But in this case, there's a judge who's pushing back a little bit, and they're saying unprecedented. They're saying that they are directing the dissemination of those very classified records outside the executive branch for a special master review. You want a referee to look at this stuff? In August 2020, they say the government obtained a search warrant to go and raid Trump's residence based on a finding of probable cause from Judge Reinhardt over a WhatsApp phone call conversation. Warrant signed via WhatsApp. To believe that the search would reveal evidence of crimes, overdue library books, including the wrongful, as far as we know, They said that these were nuclear weapons and secrets and haven't seen anything close to evidence of that yet. And they say that all of this is bringing to light the wrongful retention of documents and information relating to the national defense as well as obstruction of justice. And again, what they're talking about is going to be the custodian of records document. They're saying that Christina Bobb, Trump's lawyer, signed a document saying we gave you over all of the records and you didn't give us over all of the records. Therefore, that's obstruction of justice. Because they're singling out their political opponents to go after these types of records when the Presidential Records Act, in and of itself, as we talked about here, demands an alternative remedy. It doesn't even contemplate criminal charges. It says all of this is supposed to be rectified between the National Archives and the outgoing administration. Prosecutors continue. They say, among other evidence, the search recovered roughly 100 records bearing classification markings, including markings of the highest and extremely restricted distribution, which, that's their phrase. Again, we don't really know what it is other than it's a highly designated document. Got it. 2 weeks later, after they raided his house, Trump filed a civil action asking for a special master to review the seized materials for claims of privilege and return of the property. And they asked an injunction be issued against the government from using those materials during the review process. The appointment of a referee, something I think is completely reasonable, especially in a case like this, where it is unprecedented, where you're raiding the home of a former president. Prosecutors say district courts have no general equitable authority to superintend federal criminal investigations. In other words, courts don't have the legal authority to go and interfere with criminal investigations, which is true. Instead, challenges to the government's use of the evidence recovered in the search are ordinarily resolved through criminal motions practice if and when charges are filed. Also true. But they haven't filed charges, and they're using the investigatory phase of this case as a political cudgel, which is why everybody is demanding that there are guardrails on this, because it is unprecedented. They're saying, well, normally, listen, you didn't charge Trump with shoplifting, all right? He didn't steal a candy bar and you're charging him and you filed charges and this is going to be a routine case. No, there are all sorts of legal complexities here. And it's really a case of first imprint. Not seen before. We have a lot of issues to litigate about executive privilege and about presidential records and so on and so forth. But they want him, I guess, to just go through the regular proceedings like everybody else. Here, however, the district court granted, they say, the extraordinary relief that Trump sought, which is literally appointing a referee. That's it. No cases dismissed. They're not declaring the documents Trump. They're not saying that the U.S. DOJ can never have them again. Nothing like that. All they're saying is that they just get to look, that the special master just gets to look at the doc. That's it. And the prosecutors here are saying it's the extraordinary relief. Like, this is insane. Ordering that the special master be appointed to review the seized property and stopping the use of the materials for criminal investigative purposes until the special master goes through them. Although the government believes, they write, that the district court fundamentally erred in appointing a special master, saying that Eileen Cannon shouldn't have appointed one in the first place, and that she shouldn't have granted the injunctive relief. The injunctive relief means that the government is sort of stopped from doing something. They get an order saying you can't prosecute him on using these documents anymore. So you just have to stop prosecuting him, right? It's an injunction. And they're saying we're appealing, and they're saying that Trump is appealing the court's order. Let me back this up a little bit, because they're saying here, although the government believes that the district court screwed up at a fundamental level, and they say, and we're appealing the entire order, the entire September 5th order in its entirety on an expedited basis, which is sort of new, right? This is sort of expanding the scope of the appeal on the 11th Circuit. They're saying the government sought only a partial stay of the portions of that order, right? That's what they were seeking, Okay, so there's two things. One, they're appealing the entire order, but when we were in front of the 11th Circuit, they were only focused on certain things, and the 11th Circuit gave them those certain things while the appeal is pending. All right, so now we are there's a lot of back and forth on this, so we'll try to keep the train on the tracks, but there's sort of an appeal. There is a stay pending the appeal, which had real consequences for the district court case, and Trump is appealing basically all of it, and now the prosecutors are also basically throwing all of it at the Supreme Court and seeing essentially what the Supreme Court wants to do with it all. And we'll see, right? We'll see what they're asking for. The government sought only a partial stay of those that caused serious and immediate harm, and the Court of Appeals granted that modest relief. And they said the U.S. is very likely to succeed, saying that the district court abused its discretion, saying that the special master shouldn't have had the classified documents. Now, the prosecutors at the Supreme Court, they say, in this court, Trump does not challenge the stay insofar as it allows the government to continue its investigation. And we talked about that. He's saying, fine, you can go ahead and continue to investigate me. Don't care about that. Instead, all we want is a partial vacation of the stay to the extent that the special master can't see those 100 documents. Prosecutors say Trump is not entitled to that relief for multiple reasons. So Trump is saying you can prosecute me if you want. The only thing that he really wants, that the government is acknowledging, is that the special master get those 100 classified documents. The 11th Circuit said, nope, special master does not get them. Trump is asking the Supreme Court to turn him back over. The government prosecutors, they continue. They say, most notably, Trump has not even attempted to explain how he is irreparably injured by the Court of Appeals ruling. They say Trump's inability to demonstrate irreparable injury is by itself sufficient reason to deny the relief from the Supreme Court. They say Trump does not even challenge the Court of Appeals determination that he's not going to suffer any harm from this stay. As the court explained above, they say special master and the counsel all agree that the government would be harmed. And the government's been making this case that if they can't, go through these documents, if they can't rummage through these 100 materials, there's going to be all sorts of national security implications for this. And we're all going to die any minute now because of Trump's recklessness. And they're saying if Trump has the burden in this case because he filed this action to show that this would harm him absent a stay. The prosecutors also write, they tell us, Trump has also not shown that the Court of Appeals, in this case, the 11th Circuit, made a clear and demonstrated error. The district court appointed the special master, meaning Judge Cannon, to review claims of privilege. But they say, but Trump has no plausible claim of privilege in or ownership of the government records bearing the markings. As the Court of Appeals recognized, they say Trump thus has no basis to demand a special master review those records. So the 11th Circuit is just saying the property does belong to the government. And because they're the government's records, Trump doesn't have any claim over them. And again, we have had debates about that for months now. Applicant, they say Trump does not acknowledge, must let even attempt to rebut the court's careful analysis of those issues. Instead, they say Trump principally asserts that the court lacked the jurisdiction to do what it did. And they say that's wrong for a couple reasons. First, they say that this is inextricably intertwined with the review. And they're giving us some heavy case law here. And they're talking about these interlocutory orders. And those are the orders. Most people think about appeals as the appeal of a final judgment. So like you see in the movies and the TV shows, when somebody gets convicted of a crime, the jurors come out and they say, we, the jurors, find the defendant guilty, right? And you go, oh, and it's the end of the world. And it's not good when that happens in most cases. But what happened, but then you think of that as the appeal. Well, before you even get to a trial, there's all sorts of stuff. You might have a fight over whether the expert witness can come into court and testify. The judge might say he can't come in, and you say, well, that's ridiculous. We have no case. We want to appeal that ruling. This is all they're talking about here. They're talking about special master shall be appointed, bearing classification markings, and we've got all sorts of case law from 2009. They say the Court of Appeals thus, meaning the 11th Circuit, correctly held that it had appellate jurisdiction over the order and that it could make the rulings that it made. And so therefore, if you remember, Trump's entire appeal was basically on that basis. Trump was making the argument that the basis for the 11th Circuit appeal was unfounded. They shouldn't have even gotten the document in the first place. And they're saying that's not true, and they gave us some case law for that. Now, the prosecutors give us a little bit of factual background here. They tell us that Trump's term of office ended in January 2021, and over the next year, NARA thought that they were missing some records. The Presidential Records Act provides that complete ownership of all this stuff belongs to the government. It says that NARA shall assume responsibility for control of the records. In response, writes the prosecutors, in response to repeated requests from NARA, Trump ultimately provided NARA with 15 boxes of records back in January. NARA discovered the boxes contained items marked as classified. They had a fit over it. They said that we're all going to die, quote, exceptionally grave damage to national security if anything like this gets out. NARA referred the matter over to the DOJ, noting that the highly classified records were improperly transported and stored, and they sought access to those records. After receiving notification of that request, they asked about a claim of privilege in court, and they say that none of those things appeared to be classified or that had been classified had been declassified. So NARA has a fit. They send it over to the FBI. The FBI then is developing evidence, right? They're staking out Mar-a-Lago, and we talk about the mole at Mar-a-Lago in Palm Beach. And they say, oh yeah, there's all sorts of problems. There's storage boxes, and Melania's brasiers are in a place that might be compromised. So they start demanding subpoenas and responses from Trump. In response, Trump's counsel and his custodian of records, Christina Bobb, who we talked about yesterday, she produced an envelope containing approximately 36 documents bearing classification markings. Trump did not assert any claim of privilege and did not suggest that any of those documents had been declassified. To the contrary, the envelope had been wrapped in tape in a manner consistent with an effort to handle the documents as if they were still classified. Some of the documents in the envelope bore classification markings at the highest level, including compartmentalization. So yeah, they're giving all sorts of documents back, the classified ones that they think are classified. They give them back. It sort of supports Trump's argument. It's sort of like all of those other documents were not classified, in his opinion. The ones that they thought were problematic or might be still classified, they wrapped up in tape, and they gave them all back. Trump's lawyers represented, meaning Christina Bobb, that those records had been retrieved from a storage room at Mar-a-Lago where boxes removed from the White House had been placed, and that no responsive records were located anywhere else at Mar-a-Lago. That's the custodian of records receipt. FBI says, do we have everything here? The head librarian from NARA is going to be super angry if we don't. And so, when I was a kid, we had the little cards that you put in the library books, the little, write your... checked out by so-and-so on this date, returned by whatever, right? Slide that in there. Same thing here. We're in big trouble. So I need you to sign this document and put it in the boxes before we return these library books to confirm that there's nothing else that you have outstanding. Trump's custodian of records provided a sworn certification in writing, quote, on behalf of the office of Donald Trump, quote, that a diligent search was conducted of the boxes that were moved from the White House to Florida, and, quote, any and all responsive documents accompany this certification. The certification further stated that, quote, no copy, written notation, or reproduction of any kind was retained as to these materials. The FBI uncovered evidence, write the prosecutors, that the response to the grand jury subpoena was incomplete, that additional classified documents remained at Mar-a-Lago, and that efforts had likely been taken, oh my goodness, to obstruct the investigation. obstruction of justice because they must have signed the custodian of records wrong? Let's see. The government applied to Judge Reinhardt for a search warrant. They cited different U.S. code violations. They said willful retention of national defense information, concealment or removal of government records, and obstruction. Those were the three charges we talked a lot about. Now, we also saw that there was some issues with these charges. Notice there's no classification charges, right? They're only removal and sort of process crimes, concealment, until you get to obstruction. So they submitted that all over to Judge Reinhardt, the lower level district court judge who granted the search warrant in the first place. Prosecutors say the magistrate judge found probable cause that evidence of those crimes would be found at Mar-a-Lago, and they authorized the government to go seize those materials. The magistrate judge, Reinhardt, also approved the government's proposed filter protocols for handling any potentially subject materials, anything that might come under the purview of attorney-client privilege. And as part of the warrant that Judge Reinhardt authorized, extremely broad, almost zero particularity, he said, if you see anything problematic, not only can you get what's in that box, you get to the box to the left, to the top, to the right, to the left, behind, to front, anywhere, cross dimensions, get it all, baby. Who cares? But in that proceeding, he said that, okay, you probably, want to take some care and caution if you're dealing with attorney-client privilege materials, and he approved a filter team to go in there and sort of literally filter the documents. Anything that the investigative team shouldn't see, the filter team goes in first and segments it out so that they aren't breaching all sorts of protocols. They continue. Government prosecutors write, the government executed that warrant back on August 8th, 2022. The search recovered more than 11,000 documents from the storage room, roughly 100 of which bore classification markings. In some instances, even FBI counterintelligence personnel required additional clearances to review the seized documents. Prosecutors continue. They say, 2 weeks after the search, the applicant, meaning Trump, filed this pleading with the court, and they asked the district court to appoint a special master to review these materials for executive and attorney-client privileges and to stop the use of the government's against Trump. On September 5th, Special Master Eileen Cannon granted the request and said that pending resolution of the Special Master review, the government can't continue to prosecute Trump. The court explained that the injunction was issued in natural conjunction with the appointment of the Special Master. I mean, obviously, if the Special Master is going to be looking at these materials and making judgments, executive privilege over here, government document over there, then the government's not going to have their materials that they would presumably need for their criminal prosecution until after that work has been completed. Prosecutors say that Judge Cannon at the district court denied the government's subsequent motion for a partial stay because they submitted one on top of that. They said, Judge, we're all going to die if you don't let us continue our investigation. Can you please let us carry on? And she said, no. The court declined to address the government's argument that the special master review is unnecessary and unwarranted with respect to that discrete set of records because they say they are government records not subject to any claim of return or privilege. Instead, they're saying that Judge Eileen Cannon just sort of ignored their main thesis. Instead, the court referred generally to factual and legal disputes, and the court reiterated that the injunction that stops the government from using the materials was necessary to make the special master meaningful. It doesn't have any teeth. So the government didn't like that, right? They really wanted this to move forward and rapidly. They have to have a prosecution. They're not going to get it in before the midterms. They're unhappy. The prosecutors continue. They say, the Court of Appeals granted a stay of Judge Cannon's order. The court said, yeah, we've got jurisdiction. We can review all of this stuff. And we say that they are, in fact, inextricably intertwined. The court at the 11th Circuit said that the standards were appropriately met, saying that Judge Cannon abused her discretion. And they said that if the government is not allowed to have these materials, that there will be an irreparable injury. So Trump won't be injured, but the government will, according to the 11th Circuit. And why? The 11th Circuit read that same affidavit that we read by that FBI official who said, yeah, it's going to be the end of us. It risks imposing significant harm on the United States. Some FBI agents, submitted an affidavit. He says, we're going to suffer substantial injury and the public interest is going to evaporate if this doesn't proceed. Meanwhile, the prosecutors say the district court denied a stay, even though we had this affidavit, and even though the very honest, the very trustworthy FBI, they said we're all going to die. Judge Cannon she didn't care. She's like, good, I welcome it. Hopefully it's painful. Prosecutors say, meanwhile, Cannon denied the stay. It issued another order appointing a special master. Ugh. And after the Court of Appeals entered the stay, the Court of Appeals telling the lower level court, you're on hiatus now. The district court, Judge Cannon, sua sponte, meaning on her own, and we read this here on this channel, issued a new order. So the 11th Circuit came out and they said, we've taken a look at your prior order. And the prior order, it really did four things. If you remember, there were sort of two things they didn't fight about. And the other two things were about the 100 documents and the criminal prosecution, whether it could continue or not. So they were fighting over those two things. And when the 11th Circuit came back down, Judge Cannon went back to the original order and she basically struck them out. She said, all right, well, I guess the 11th Circuit, they told us differently. So, okay, pull up that order. She said, give me a Sharpie. And just crosses out the two things and then republishes it. And she did that on her own. Nobody asked her to do that. So the government prosecutors are bringing that up. They say she did that. She deleted portions of the order addressing the review of the records bearing the classification markings. In other words, Special Master Raymond Dearie is no longer ordered to do those things because she just scratched them out. After the Court of Appeals granted the stay, it also granted the government's motion to expedite the appeal, the one that we're talking about that would eviscerate, that would get rid of the special master altogether. They got to stay first, and now they want the whole order gone. Briefing is set to be complete in that case in the Court of Appeals by November 17th. So still plenty of time on that. Meanwhile, the government's investigation is ongoing, as is the national security review that's being conducted by the Office of the Director of National Intelligence. That's why they're saying this is so urgent. Now let's take a look at some of the quick arguments here. As is usually the case with these sections, lots of case law, very heavy. So we'll take a quick look and see how quickly we can get through it. But we're on page 17 of 34. It says that Trump wants to vacate the partial stay that was entered. And you can see they're talking all sorts of standards here. A stay that's granted by the court is only appropriate when all this is case law. So we'll fly through this. They say Trump makes very little effort to show that they would be successful on the merits. Trump has not shown that the lower level court was clearly erroneous, saying that their analysis just doesn't carry weight in that basis. The Court of Appeals does have jurisdiction. Remember that Donald Trump was making a big claim that they were appealing this on an interlocutory basis. They have a footnote here. They say Trump is wrong to suggest that because the district court appointed Dearie and specified the details and the mechanics of his review in the order, that they also effectively stayed that order too. They say the district court, this is a little bit spicy, and they tuck this away in a footnote. Government prosecutors say the district court itself, meaning Judge Cannon, apparently, when you use that language, apparently did not understand the Court of Appeals to have stayed any portion of the September 15th order, because after the stay was entered, the district court on its own modified the order to conform with the stay of the September 5th order. So they're saying that there's all sorts of confusion that's existing between even the Court of Appeals at the 11th Circuit and the district court. They're saying Judge Cannon doesn't even really know what she's doing. Oh, it's going to be funny to see what happens. If the Supreme Court sends this stuff back to Judge Cannon, she's not going to be happy with this. She's going to be like, what did you loser prosecutors at the DOJ say about me in footnote 3 when you were in front of the Supreme Court? What'd you say? Why don't you read that to me there on page 17? Oh, it says that I didn't understand. Oh, apparently I didn't understand the Court of Appeals. Right? Judges don't like that at all. Judges don't appreciate that. All right. I understand it perfectly. Okay. I understand it exactly right. And don't tell me differently. So it's going to be interesting. Not going to be happy with those prosecutors. They talk about Clinton versus Jones. They talk about presidential immunity. They say the injunction here is immediately appealable under different rules. And that was Trump's basis for the appeal to the Supreme Court. He said they don't even have jurisdiction over any of this stuff in the first place. They write, Trump asserts that the two are not intertwined, but they say that they are. They continue, they say the Court of Appeals had jurisdiction over the entire order. And so as you can see, most of these are the arguments that we've already fleshed through already. Collateral orders, very technical stuff, as you would expect in a Supreme Court docket. So let's take a look at some of the concluding language before we wrap up on this segment. Here they close out in section 3. This is page 32 of the government's Supreme Court appeal response. And they're arguing to Judge Clarence Thomas. They say, Trump is not going to suffer any irreparable injury if he doesn't have the special master look at the 100 classified documents. They say that what Trump is challenging from the Court of Appeals, all it does is simply prevents dissemination of the documents from going to the special master while the government's appeal proceeds. Now, it's really funny what they're saying here. Look, this language is very clever. I actually think this is very clever. They're talking about this. This is a pejorative word. You know, we often talk about we call this emotive conjugation in the law, where you say take a word and you add some emotion to it and you conjugate the word in a way that adds meaning to it. So an example that we often use on this channel is, think about the same conduct of a person leaving a location. One person is in a physical location, a little mind experiment. One person is in a physical location and the action is they physically move from one location to another location. There's a couple different ways you can say that. Okay, one way you could say that is Johnny went home. He was at one location and he went home. Easy. You could also say he left. Where'd Johnny go? He left. Or he traveled to that location. He's now here. Okay, it's another action. Or you could say Johnny fled the scene, right? He sort of left. He left one location. Johnny went home. He left. Johnny went somewhere else. Johnny fled the scene. Different ways to say the same thing. It's the same action. Here, what they're talking about is the DOJ is preventing the dissemination of documents bearing classification markings. Preventing dissemination. It's not going to the New York Times, which they're okay leaking to, and the Washington Post. It's going to Judge Raymond Dearie, who's a very qualified, very accomplished Eastern District of New York judge who served on the FISA court. So they're talking about preventing dissemination to the special master. It's not going to anybody else. But you see the word that they used. They could easily substitute that word in. Court of Appeals partial stay simply prevents the transfer of documents bearing classification markings. But they call it dissemination because it's got a very negative connotation to it. It's a pejorative framing. Because if it's disseminated, who knows who can get their hands on it. But here they continue. They say, that limited relief imposes no harm, much less irreparable injury on the applicant. The applicant does not seriously argue otherwise. Indeed, Trump devotes only 2 sentences to irreparable injury. He says it's unnecessary for him to make that showing because the government's not likely to succeed on an appeal. And they say, look, Trump's claims cannot be reconciled. They say there's other cases from the U.S. Supreme Court, from Judge O'Connor, that says that the standard is how we see it, not how Trump sees it. And they also say that Trump is also asserting that he could be irreparably injured. And that if the government uses those materials, it could eventually lead to harm. And they continue, they say, because Trump has no plausible claims of privilege or ownership, which is the key issue that has not been litigated. The Supreme Court is ultimately going to weigh in on this. Who has possessory interest of those documents? Are there any situations in which Trump is protected? He sort of maintains a possessory interest in them. Is it presidential records? Don't know. Is it declassification? Don't know. Is it attorney-client privilege, executive privilege, work product doctrine, any of those things? Don't know. Supreme Court is ultimately going to tell us. But the government says that Trump is going to suffer no harm if the special master doesn't get those materials. And therefore, Trump is undermining his own claims, they say, by opposing the government's motion, and that he hasn't established any irreparable injury, and therefore we're asking the court to deny his request to disturb what they say is a modest partial stay entered by the Court of Appeals. In conclusion, they say the application should be denied, submitted by Elizabeth Pre-Logar. Elizabeth Pre-Logar, the Solicitor General. It's very interesting, the modest partial stay. I think it's pretty modest to ask for a special master, to ask for a referee to come in and monitor the entire investigation just to make sure that the corrupt DOJ that is highly politicized is not prosecuting their political enemies in a way that's inappropriate. That seems pretty modest. Seems pretty reasonable, but evidently not for the DOJ. They say that Trump should be reasonable in not having a referee step in and monitor what it is they are doing. And so that, my friends, is a big update. The government prosecutors submitted that request. Let's take a look at the Supreme Court docket and see if there's any new updates here. And as we can see, there are not. So these were the 3 entries that we had talked about at the start of this segment, but nothing here at the conclusion. We can see the Solicitor General, Elizabeth Pre-Logar, sent all of that in. I'll expect to see another order, probably from the Supreme Court, maybe tomorrow, with further instructions. But that, my friends, is it for the Trump segment. Some serious heavy lifting on the SCOTUS case. And once SCOTUS hits, it's going to work its way all the way down. It's going to hit the 11th Circuit, back down to Judge Cannon. We'll see what Special Master Raymond Dearie does, and we'll see ultimately who ends up holding on to those documents. But thank you for liking this video before you head on over to the next one. And thank you for subscribing, and I look forward to seeing you the next time we have a major Trump update here.